Hi. So today I am going to share with you why credit card issuing companies or banks do not file a civil case against you if you default a credit amount that was taken from the banks. First of all, you should understand that the credit card loan, whatever you are taking, is a civil case, will attract a civil case. It is not a criminal case. It is simply a personal loan in the form of a credit card scheme. Only remedy the credit card companies have if you default is that they invariably they can go to civil court. They have that right to go to civil court, but they don't go. The only remedy they exhaust is that they report to CIBIL and damage your CIBIL score. What is CIBIL? CIBIL is a credit rating agency which examines your credit and based on your repayments, etc., etc., it examines your credit worthiness, how credible you are for taking loans from banks, etc. Now the one remedy they have is that they report to CIBIL. The other remedy they have is that they sell that asset. Now if it is a liability in your books, the loan taken by a borrower, that is you, if it is a liability in your books, it is an asset in the books of the bank. So the banks have the right to sell that asset. So they sometimes, in some instances, they sell the asset also. Or else they resort to the cheap recovery techniques, that is to say they attack you emotionally by employing people who can speak vulgar language. Of course, you can file a police complaint against them if they speak vulgar language and try to attack you emotionally. So that's a different ground you have against the credit card companies. But here I am going to discuss about why credit card companies do not file a case against you if you default. Unfortunately, today litigation has become so expensive that even corporates are finding it difficult to sustain the litigation in the courts because due to delay, because the case is dragged for years together, and even corporates are finding it difficult to sustain a court case. Forget about common man. So this is the situation. Even corporates are finding it very difficult to sustain a court case. In those circumstances, that is to say, even if the amount is in crores of rupees, also they are unable to sustain a court case because it is an expense on their balance sheet. Because if the amount is in crores, advocates charge in lakhs of rupees per day. So that is an expense otherwise. So here for meager amounts like below 2 lakhs, to bank below 2 lakhs is a very small amount. So they can't afford the litigation expenses. So it is better to write it off, or it is better to sell it off, or it is better to employ third party and give him some good percentage and try to recover. So that is how banks are doing these days. It is cheap to employ some customer care executive and try to recover, or these days they are using artificial intelligence and machine learning technology trying to recover or trying to inform the due date or trying to inform the dues that are beyond the scheduled date. So therefore my suggestion would be to pay. If you are capable enough to afford a CIBIL damage to the CIBIL score, because remember, once a CIBIL score is damaged, it is damaged forever. You can't restore it back to the original state. And if you're thick skin and if you are capable to afford the damage to the CIBIL score, then I think you can default. But I don't suggest it. But the advantage you have is you can negotiate with them. Now you know the reason why they don't file a civil case against you. Now what is the weapon or what is the shield you have in those circumstances is that you can buy time. You can buy time and you can negotiate with them to remove the penalties, because I doubt that, I don't know, I have to check the law, because I doubt that even the penalties are illegal or the penalties are exorbitant. I don't think RBI allows the credit card companies to or permit the credit card companies to charge such hefty penalties. One. The second is, I'm also doubtful about the interest rate, because I have not seen law permitting the credit card companies or the banks to charge 36% per annum on the credit card dues. If you are aware, I'm not surprised, but if you are not aware, please note it, you are being charged 36%. And a person in debt is not bothered about the interest rate, unfortunately. So therefore, the advantage what a customer has is that you can buy time and you can negotiate with for the removal of those penalties which are exorbitant. For that you can also go to consumer court, but if at all you are going to consumer court for penalties or for exorbitant penalties or for the interest rate of 36% or 42% per annum, please note that you make the payment and go, because otherwise your CIBIL score will get affected. Whenever you are trying to fight with the bank, you must note that you have to employ the principle called the pay and recover. So you can pay and you can recover through the consumer court. That is one remedy you have as a customer. I hope I'm clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.